Okay, guys, it looks like people are populating in. So we are going to start the webinar here. I have 12 noon CT. So let's begin. Welcome to our program. Today we're going to discuss the state of tech antitrust law and what to expect from the new Trump administration enforcers as to tech and intellectual property. My name is Hill Wellford, and I'm an antitrust partner in our DC office, where I concentrate on government-facing antitrust work in the US and abroad, including counseling and investigations and HSR Act merger control filings and their equivalent overseas. Relevant to today, I've been both a staffer at the DOJ Antitrust Division here in Washington, D.C., and then later a politically appointed chief of staff here. So I've got some experience with how the politicals and change of administrations can affect enforcement. With me today is Mike Scarborough, who is an antitrust partner in our San Francisco office. He also maintains a desk in Washington, D.C. Mike does some of what I do, but most importantly, he's a genuine courtroom litigator. In fact, Mike is our senior most antitrust litigator in California, might be the most senior antitrust litigator in the firm. I should have checked that. Where tech work is a big part of his resume, as you can imagine, being in the Northern District of California. We've got a full hour of material today, but to the extent we're able to do so in this remote format, we would like this to be an interactive discussion. So with that in mind, a couple of housekeeping items to note before we begin. First, pretty please, ask us questions throughout the presentation. We're going to plan to pause a few times to answer several questions at a time, just to sort of break up the flow. To submit a question, use the chat function. That's going to be at the bottom or to the side of your screen, depending on how you've set up the Zoom window. You should see the speakers at all times and also the presentation slides on your screen, but if you're on a mobile device, that might be modified a bit. And finally, this is a CLE accredited course. So if you are seeking CLE credit, please keep an eye out for the polling questions that will pop up during the presentation and make sure you answer them. That's how we verify your attendance. This is a required step under the state bar rules. You'll be alerted through the chat when a polling question is live. Okay, Mike, enough with the preliminaries. Let me kick it over to you to kick off the substance. And can you give us the next slide, please?
Thank you, Hill. Thanks for that kind introduction. Let me just dive right into it. So as most of you all know, at least for now, there are two federal agencies that enforce the antitrust laws in the US. We have the Antitrust Division of the US DOJ, and we also have the Federal Trade Commission. Under the Biden administration, both of those agencies advanced what is widely considered a historically aggressive enforcement agenda. We saw lots and lots of enforcement actions against big tech companies. Really, most of the major tech companies ended up with one or more lawsuits against them. We saw a general hostility towards merger and acquisition activity. And we saw the introduction of what practitioners, I guess, would describe as non-traditional concerns when things like mergers were being evaluated, such as harm in employee labor markets. And we also saw a variety of actions having to do with no-poach enforcement, things like that. So folks have been wondering how much of that is going to change with the new administration and the new leadership of those agencies. And I think the short answer, which we will dive into, is perhaps not as much as some people were expecting. And there definitely have been some interesting wrinkles. So let's start by looking at who the new leadership is in these agencies. If we could go to the next slide. Okay, so at the Antitrust Division of the Department of Justice, we have confirmed new leadership. This has happened fairly quickly, and that is Gail Slater as the Assistant Attorney General for Antitrust. Generally, in the practitioner community, She is regarded as a very mainstream pick. That is reflected in her confirmation process, which went very smoothly. She got what is these days fairly rare bipartisan support, and she's up and running the agency. Just some points on her background. She was an economic policy advisor to the Vice President, J.D. Vance. She served on the White House National Economic Council during the first Trump administration, and she put in over 10 years at the FTC as a staff attorney, where she worked on several big merger investigations and cases, including a challenge to a Whole Foods acquisition. She also has substantial private sector experience working with Fox and Roku and the Internet Association. And despite some of that background, she is expected to continue the prior administration's focus on aggressive enforcement against tech companies. And we are definitely not seeing any move to drop any of the current investigation or cases that are going on against tech companies right now. If there's a takeaway for this kind of mainstream selection, it would be that Slater may be expected to be a little more surgical in the division's approach to tech enforcement rather than what some call kind of a sledgehammer approach that was done with the prior administration, but it is not going to be any kind of radical about face. So why don't we go to the next slide and talk about the FTC? So at the FTC, the current leadership is being run by Andrew Ferguson, who was a commissioner in the prior administration, and so basically just took over when he was designated as the chair when President Trump took office. So Chair Ferguson has some pretty sterling conservative credentials. He was the chief counsel to Senator Mitch McConnell. He clerked for Justice Clarence Thomas on the Supreme Court. And he's been very vocal during his time as the minority Republican commissioner during the Biden administration to push back on some of the things that he thought were improper in what the Democratic-led FTC was doing during the Biden administration. Among some of the things he complained about, and some of his talking points, he said he wants to reverse Lena Khan's anti-business agenda, wants to roll back burdensome regulations, and to stop her war on mergers. At the same time, he's really not said anything that suggests that the FTC is going to roll back the general strong enforcement against big tech companies and what's regarded as big tech monopolies. He is, as we will get into a little bit more later on, he is pivoting some. One of the priorities is looking at big tech companies that may be engaged in unlawful censorship of conservative views. So we should expect to see continued enforcement against big tech companies, but it may pivot somewhat in how it's being done. Let's go to our next slide. Okay. The expected third member of the Republican FTC commissioners is Mark Meador. And Mr. Meador is poised to be confirmed anytime now. He's gone through a nomination hearing. He's been advanced out of committee, and he's expected to be approved without a whole lot of fanfare. He's been an antitrust attorney in private practice. Fairly notably, he represented the social media platform Rumble in its antitrust lawsuits against Google. He's also served as chief counsel for Senator Mike Lee of Utah. And generally, what his statements have been leading up to his expected confirmation have been very much in line with Chair Ferguson's. Let's go to our next slide. Okay, the big news on the FTC front, and it's hard to believe that this happened just last week is that President Trump fired the two sitting Democratic FTC commissioners. That happened on March 18th. And there is immediately some expected legal challenges associated with this. There is kind of behind this, there is a 90-year-old Supreme Court case that confirmed that in pretty much this analogous situation, that FTC commissioners can only be removed for cause. The specific language in the statute at issue is for inefficiency, neglect of duty, or malfeasance in office. However, there is some legal scholarship that suggests that this case doesn't really reflect the current political and legal environment, and that the unitary executive theory may override this approach. So what we are expecting is that we're going to see legal challenges to this that may ultimately roll up to the Supreme Court. Okay, let's go to the next slide. Okay, so let me just pause for a moment and say, because we're going to be in a period where right now we have two commissioners, we will likely soon have three commissioners. The FTC will still be able to act, but there may be some questions about the legality of the actions that will be taken during this period while the removal of the Democratic commissioners is being challenged. So the best advice we can give you right now is, if the FTC takes action, you can't ignore that. But ultimately, how all that plays out in the courts, it may be that some of the actions that are taken in this kind of period of limbo may be subject to challenge as unlawful based on the removal of the Democratic commissioners. But let's talk about what we expect to happen in the immediate future. So we expect the priorities of the FTC right now to continue apace with enforcement as to enforcement against technology companies. All three of the Republican commissioners, including Mr. Medor, is expected to be confirmed, are very pro-enforcement against technology companies. We've got actions against Amazon. We've got actions against Google. One of those was actually initiated during the first Trump administration that's about to go into a very high-profile remedies phase. None of that is being pulled back while we have this transition to the new administration. Some of the other things that are going on right now is we do have a fairly substantial pivot, particularly at the FTC, to talk about DEI and ESG issues. And it's not entirely clear how this is all going to manifest, but we have, for instance, in February 2025, the FTC launched a joint labor task force that was aimed at looking at a variety of practices in the labor markets. One of the targeted practices we've heard is going to be collusion or unlawful coordination on DEI metrics. And on the ESG front, we should expect that there will be some investigations that will be launched that may mirror some of the litigation activity that we were already seeing. For instance, there's litigation going on right now in Texas by a variety of red state attorneys general against State Street, BlackRock, and Vanguard that has to do with alleged collusion to reduce coal company production through the ownership of those companies by those defendants. It's possible that the Antitrust Division may also get in on that action. So just a few other enforcement priorities to note on the next slide, please. Okay, so one of the things that we've heard about, particularly from the FTC side, is we've heard some rumblings about content moderation, particularly content moderation as it speaks to conservative viewpoints. There's been a public inquiry that has been launched at the FTC Unclear exactly who the targets are going to be of that, but you can imagine it's some of the big social media companies that that you would expect. And we also should expect that AI is going to continue to be an evolving focus for the agencies. And there's a lot of different things which I'll actually speak to later in the presentation about the competition concerns associated with AI, but we expect that to be a further focus for this administration. Okay, let me go one more slide and let's talk about merger enforcement. This is one of the areas where perhaps we could say, at least in the early going, that it's more of a surprise than people were expecting. I think the general consensus was that while a lot of the tech enforcement would continue, that there would be much lighter pressure on merger activity from this administration. And so far, really, that has not borne out. We've already seen the Trump DOJ sue to block a acquisition by HP. And I think more tellingly, we've also seen in the FTC side, the Chair Ferguson has said he is not withdrawing or rolling back reliance on the 2023 merger guidelines, which is something that I think a lot of folks were expecting him to do. And so I think what we should expect is, at least with respect to merger enforcement, there will be much more continuity than perhaps folks were expecting. But let me pause there, and if there's any questions, we can address those. Otherwise, I can hand it off to Hill to continue on.
So I don't see any questions from the audience yet. I'll ask you one, which is Metter came out of the Mark Metter, the nominee, came out of the Senate Judiciary Committee, sorry, Senate Commerce Committee on a bipartisan vote, but that was before the two Democratic commissioners were summarily fired or attempted to be fired. What do you think is going to happen to his Senate full floor vote as a result of that?
You probably have as much inside baseball on that as I do, Hill. My view is that it's probably unlikely to block him. The statements that we've heard so far is that the FTC is empowered to act. Frankly, with even one commissioner, it can still do a lot of the things that it needs to do. Can certainly do that with two commissioners. Adding the third Republican commissioner isn't really going to change things. And I think to the extent that political pressure is going to be thrown behind what has happened to the Democratic commissioners, it will be in whatever legal challenges arise from those firings. That's just my personal view, is that it's unlikely to create brand new substantive obstacles to Meadow being confirmed.
Yeah, I think that's right. I think, unfortunately for Mark Metter, who was otherwise, I think, an uncontroversial nominee, it's hard for me to believe that the Senate Democrats are going to essentially take it lying down. They're more likely to, it's at least possible that they're going to, as a matter of principle, basically vote against him and force that all the way to a 51-49 vote or a J.D. Vance tiebreaker, which is unfortunate because although I have some policy disagreements with Mark Metter, I think he's a mainstream, very, very well-respected guy. So it's unfortunate he might get sort of dragged into the middle of that. I do expect him to get confirmed, and as Mike said, the difference between one or two or three Republican commissioners, it's a majority either way. You may have seen some misreporting on this. It used to be the case that there was a quorum requirement where you had to have at least three FTC commissioners in order to act. That is no longer true. They changed the rules some years ago. And even if there is only one non-recused FTC commissioner, that one commissioner can act and do anything necessary, vote for or against a merger, for or against a policy position, or anything else. So the quorum issue is not a real one. The political sort of hostility may be going off the charts. We're just going to have to see about that. Any other questions that you see or you want to address, Mike, or should I jump into part two?
Well, I think let's keep moving on, Hill.
Okay, can we go to the next slide and the one after that? First says IP antitrust intersection. There you go. So since the new administration might be planning to make some changes, I wanted to make the point that these changes are probably going to be pretty small or marginal, because in the past 20 years ago, antitrust law has largely settled 3 areas of the tech antitrust controversies that were around, and it's now working on a 4th. The first of these is the basic relationship between IPR and antitrust, or as people like to say, the intersection between patents, intellectual property, and antitrust law. For most of the 20th century, you got really colorful statements in prominent Supreme Court and appellate cases, such as patents grant monopolies and antitrust law takes it away, or patents and IPR are in fundamental tension, or one of my favorites here was from the Microsoft case right at the beginning of the 20th century, where it said Microsoft's claim to an absolute unfettered right to use its intellectual property is no more correct than the proposition that it gets to swing its own baseball bat without giving rise to tort liability. I've always really loved this because the image of sort of scrawny Bill Gates standing there with a Walking Dead style baseball bat wrapped in barbed wire, smashing his opponents, has always brought a smile to my face. But these sort of quotes that were around in the 80s, 90s, even before that, they were really colorful. They made good media. They quoted in the paper. Business people didn't find any usefulness from them at all. They couldn't predict where antitrust enforcement was going to go in the agencies or in private litigation, and they found it really frustrating. What started to improve the situation in terms of clarity and predictability was a bipartisan effort. Remember what that used to be like back in the day. A bipartisan effort by Democratic and Republican antitrust enforcers to let economics guide this area. As they did that, both of these sort of assumptions that you see here in the first part of the slides got re-examined. In antitrust, in patent area, they really drilled into the idea of what is a patent monopoly. For example, does that have any economic meaning? A monopoly over a particular molecule, for example, for a heart drug, is when you might have a monopoly for one particular molecule, but another person has a heart drug with a monopoly for the other molecule. If those 2 heart drugs compete, then they're not monopolies over the entire market, for example, for heart drugs. Monopoly means to antitrust or to antitrust economics the ability to price without regard to competition in a well-defined category of products or services. Intellectual property really does not always do that, maybe doesn't even often lead to that. At the same time, they looked back at antitrust, and this is partially Robert Bork and Antonin Scalia in the courts, taking the view that antitrust really is not anti-monopoly. It's about something else. It is about consumer welfare. And you get this great quote from the Trinco case in 2004, written by Scalia, which said, compelling a successful firm that got there on its own to share the source of its advantage is in a lot of tension with antitrust law, since it might lessen the incentive for the monopolist to go forward and actually do those things that we want to encourage. That was not an intellectual property case, but it obviously is picked up by patent owners and has been used by them. Can we go to the next slide, please? So what we ended up with is a bipartisan consensus that antitrust and intellectual property are both after the same thing, which is consumer welfare, the benefit of consumers in a long-term view. Antitrust law, you see that that started showing up even around 1980. In IPR, there was a re-examination of that being ultimately for the benefit of consumers, with the idea that IPR, although it is a short period of time of exclusivity, has a limited amount of exclusion under the phrase, both scope and duration are limited. Consumers or society gets the greater part of intellectual property, and that's why it is encouraging long-term consumer welfare. The chair of the Biden FTC, Lena Khan, did briefly throw some of this into doubt when she attacked the consumer welfare standard and said she did not like it. She said basically that it prevented the progressives from going out and bringing some cases that she wanted to bring. She instead wanted to use a structural approach. But that structural approach, or that non-consumer welfare standard, was mostly rejected, including by Democratic appointees in the courts. It's mostly failed in the courts. Towards the end of the Biden administration, they became rather quiet about getting rid of the consumer welfare standard. When they were filing cases, they were definitely emphasizing consumer welfare. And it's very clear that the Trump administration rejects that. So I believe that we are definitely still in a consumer welfare world. Also, there was sort of a procedural matter in an IP antitrust case. It was made very, very clear, both by the agencies in this policy document you see here, and in various different litigations that did and did not involve the agencies, that an IP antitrust case is first and foremost just a regular antitrust case. You have to start by proving market power and an anti-competitive restriction and antitrust harm, meaning an injury that stems from reducing competition, not just an injury from having a patent, for example. So all that got settled pretty well. Next slide, please. And here is how the modern view is explained today. It is that core intellectual property rights are beyond the reach of the antitrust law. That means the IPR rights that are actually reflected in the statutes themselves, the patent grant itself. That's the ability to exclude unilaterally and unconditionally, the ability to license for fee. And again, you find those in the statute. It's only the non-core restrictions that are subject to potential antitrust scrutiny. They're not necessarily illegal, but they're potentially subject to claims, such as conditional refusals to deal, saying, I will only deal if you do the following business thing. Conditions that have to be beyond the statute grant. So it's not just a condition of pay me a fee, it's a condition to do something with your business. Or licensing and then terminating a license, which is one of the really big ones. This comes to one of my favorite pieces of easy to remember counseling advice about technology licensing, which is don't start, but don't stop. And what that means is it comes out of two cases involving copiers. One was called Kodak One. Here you get the site on your screen, and the other was independent service organizations. That site's down there as well. In one situation, Kodak, copier maker, was making a lot of copiers. Copiers stopped selling as well, and it decided to protect its revenue stream. It was going to get more into the servicing of the copiers, which previously it had basically left to third parties, and it pushed out those third parties by not giving them patent licenses, not giving them parts, and they sued, saying that's a bait and switch on us, as opposed to the independent service organization's situation where Xerox had never allowed such things and continued not to allow it. Kodak suffered an antitrust loss. Xerox got the antitrust win, and people took that from that be very careful how you start licensing, or you will start allowing infringement, or you start allowing parts, because you may not be able to stop it. But if you never start it in the first place, you should be good. Next point, next slide. The second item that has mostly gotten worked out is standard setting organizations and standard essential patents. You see here a alphabet soup of acronyms. Basically, this is the concern that when you are setting up a technical standard, it can be captured by intellectual property owners who allow the standard to develop in a particular area, or maybe even push it in that particular area. They don't tell you where their patents are, and then they pop out at the end of this and hit you with an injunction. And by doing so, the argument is that they are holding up the standard, and hold up is not just, I want a fee at all. The concept of hold up is that you get, by threatening injunction to a standard that has already gotten off the ground, you get more of the value of that patent, a higher royalty, for example, than you otherwise would have if people had known what you were planning to do from the beginning. Post-standardization litigation, by the way, the poll is now up on screen, so don't miss your opportunity to click yes. Post-standardization litigation proved really ineffective in getting what people wanted, which is the concept of patent peace, the ability to go forward and predictably implement without getting sued for an injunction every 5 minutes. There was a series of cases that flailed around in this area. The most important one was Rambus versus FTC, which Rambus, the owner of the patents, won against the FTC in the DC Circuit Court. In that situation, the standards implementers claimed that Rambus had come out of the woodwork at the last moment with DRAM patents and had sued them for an injunction when they weren't expecting to get sued. What the FTC ruled against Rambus and won at the trial court, but Rambus then not only won an appeal, but won the case completely. They dismissed the entire case, vacated it, and closed it under the theory that Rambus's duty to actually disclose its patents and disclose its patent royalty plans was not sufficiently clear in the standard setting organization, and the FTC couldn't use antitrust to imply a duty afterwards. Patent pooling emerged as a partial solution to this, and this is a situation where you might think, well, are the Rambuses of the world happy that they can go out and hold up, if that's the allegation? The answer was not really. The patent implementers don't make a lot of money if people aren't implementing. So the patent owners don't do well unless everybody is implementing the standards very confidently, aggressively. So what you saw was that IP owners would go out and they would pool their patents. They would put their patents together in groups of portfolios so that there would be a more efficient licensing process. This was a good partial solution, and DOJ issued a whole series of business review letters basically saying, we agree that these otherwise powerful companies can get together and pool their patents because it's efficient to license. But it was still seen as a kind of a half measure, not quite as good as getting standardization right. Next slide, please. What really changed things was an FTC settlement in In-Ray Motorola Mobility in 2013. What happened was Google, which is the publisher of the Android operating system for mobile phones, it was facing a patent thicket for mobile phone technology. And it decided, after having all sorts of trouble with implementation and getting sued, it decided if you can't beat them, join them. And it bought a patent portfolio for Motorola Mobility so that it could basically arm wrestle with other patent holders on an equal footing. The FTC went after Google, saying that it was pushing too hard. Google said, well, why are you going after me? I'm doing what everybody else is doing. And they got together, and because Google was on both sides of this issue, it owned the patents, but it was also a major implementer. it had an incentive to try to figure out this correctly, and it created a settlement that has since become kind of the gold standard. The elements of that are that a standard organization can put forth a requirement that patent owners must disclose their patents, they must make and they cannot revoke afterwards their FRAND commitments. That can be a general FRAND commitment or can also be numerical. It can say a certain portion of the value of the unit sold or whatever it is. You can't seek an injunction against a willing licensee. This is really the key item. The concept of a willing licensee, someone who is negotiating royalties in good faith and is proceeding, they're planning to actually pay a royalty. They're just trying to figure out how exactly to do it. So long as you are making progress towards that negotiation, you cannot bring an injunction as a patent holder. And then if you finally hit an impasse, but an arbitrator thinks that the implementer is not just being completely unreasonable, you can submit that to arbitration, and the arbitration will establish the royalty. A lot of patent holders don't particularly like this, but it has been more or less endorsed by the agencies, and it is the way that most SSOs now operate. And generally speaking, patent peace has broken out. So this is largely settled as the way to get it done.
Next Hill, slide. We have a question here, which this might be a good point to address it, which is, to what extent does it matter whether someone is a patent owner is participating in the making of the standard, as opposed to simply having their patent adopted as part of the standard? You know, for instance, you know, Rambus either was or should have been actively participating in the creation of the standard that was at issue in that FTC case. But does it matter whether the patent holder is actively participating in the standard setting process from an antitrust perspective?
Yeah, it matters a lot because this is ultimately contractual. If you're the ability to require somebody to do these things, can we go back to the previous slide, please? These several steps from the Google Motorola point, and in particular, the idea that they won't seek injunctions against a willing licensee, that's ultimately contractual. That's where they sign a patent pledge. People call it different things, but usually something like a patent disclosure or a patent pledge, because the implementer is part of the SSO already. So contractually, they're signing on to saying, I will do certain things, and in exchange for that, you're more likely to use my technology. If you are outside of that, if you're not participating at all in the particular SSO and they use your technology anyway, then you're kind of still back in the original situation we were pre-2013, where there's no contractual constriction on your ability to seek an injunction or to avoid going to arbitration over that if you reach an impasse about your negotiations. You have seen a couple, I don't want to name them, but you have seen a couple of the larger implementers take the position that they're just going to stand outside. They believe their portfolios are so important that they're going to be read-ons by standards anyway, so they're going to stand out and not be involved in this. But for the ones that are participating, almost everybody is signing these patent pledges in one way or the other, and they're sort of under a contractual obligation to proceed this way. Let me move on to the next slide now. The third thing that has mostly been worked out is called platforms and two-sided markets. A platform is an underlying technology base upon which other technologies are developed and used. The classic ones are the mobile phone platforms, iOS and Android, and also the payment card networks, Amex and Visa. There is, believe it or not, I think you've probably gotten so used to the idea of two-sided markets in economics now, whether you talk in those phrases or not. Believe it or not, it used to be the case that economics really struggled with this because there was a concept that you cannot justify in-market harms by out-of-market benefits. In other words, if one side of a platform is not making a whole lot of money or is feeling misused, but the other sides are all extremely happy and consumers in the whole are better off, it used to be very difficult for antitrust economics to say, I'm going to take into account the benefits to the other sides of the platform to balance against the harms to this one side of the platform that is complaining. There was a kind of a revolution. Ultimately, there was a particular two-sided markets article on this that became the standard, and eventually the antitrust agencies and the courts came to the view that yes, you do have to look at these holistically. You have to look at the entire benefit behavior of the platform, the economic benefit of the platform, and yes, we will tolerate, at least in the platform context, a situation where fees might be, for example, close to zero on one side so that the benefit can be larger on the other. Can you go to the next slide, please? Another issue that came up is what do you do about the fact that platforms need sponsors that, for lack of a better term, throw their weight around? Platforms need somebody on top of it who tells different parts, different participants, you can and cannot do the following things because those things would either benefit or would hurt the platform as a whole. One of the major ones here, this is a visual illustration of fragmentation in mobile phone systems. This mostly affects only Android because Android is open source. If you change the too much of the operating system, all of a sudden apps will not work on that. And then consumers will try to figure out, do I blame the operating system? Do I blame the manufacturer of the phone? Do I blame the app for not working? And that leads to great frustration. And ultimately, people depart from your platform and go to the other guy's platform, which is not a good thing for that anybody in the ecosystem. Clearly, the traditional one market at a time sort of economics wasn't working, so we took the view that we've got to tolerate strong platform hosts, and we've got to tolerate harm or at least less value to one part of the system than to the other. Next slide, please. So one of the things that has really come out is as you analyze these and you see this in cases, the solution is to be very careful about which kind of competition you are talking about. Is it ultimately, are we talking about an action by a platform sponsor that benefits the competition between the platforms? For example, making Apple iOS or Android operating system more secure, more safe, more seamless, working better with all apps? Or are we talking about competition within a platform, in which case the role of the sponsor is less important? That is the theory. So this is sort of how things have settled out, and it usually works pretty well. So, so what does that say about the mega platforms and the current cases that DOJ and the FTC are bringing? And there are also some private ones as well, for example, against the app stores. Well, you remember these principles that I started out with, the idea that successful firms don't need to share the source of their advantage, and you can not start, you're allowed to not start sharing as long as you haven't stopped. The answer is those principles are under some tension with the current cases. In each of these cases against Apple and Google having to do with the app stores, there is an allegation essentially that they are not allowing apps on these app stores to have their own payment systems. They're charging a revenue fee that's too high. They're discouraging sideloading of apps instead of apps through the app store. The app store manufacturers or publishers, which are also the operating system publishers, Apple and Google, are responding. no, this is about safety and security. It's not about economics primarily. It's about running, and by the way, running the App Store costs money. So who are you, the court, to set the price about what we charge for doing that? Apple lost in a bench trial, although only on one of the claims. Google lost on a jury trial under many claims, and there are several other things that are making their way through the courts now and ultimately through appellates. Um, those are still unclear, still unsettled. We don't have rulings and everything. So all I can say at the moment is keep watching. But the question is, how much does this affect you if you've got a platform? The answer is, I think probably not tremendously much, because if you have to be an absolutely mega platform before the courts seem to be departing from the Trinco theory. And also, there is at least the argument, this is the argument that the plaintiffs are making. Obviously, the defendants disagree with it, but there is at least the argument that there has been, so the plaintiffs say that there was a reliance that Google and Apple have changed what they are doing over time so that it falls under the don't start but don't stop Kodak and independent services organizations sort of counseling advice. Apple and Google would respond, well, of course we've changed what we're doing over time. The industry is changing, the technology is changing. You can't tell us that we're never allowed to do anything differently. That would be insane into a platform context, but at least allows enough of a thin wedge that the plaintiffs have been able to drive antitrust claims through it. And that is what we're going to see worked out ultimately through a series of appellate decisions over the next couple of years. So that's where we are and how far we have come and where we currently are in some of the antitrust controversies. And Mike, I will turn it back to you to talk about the ultimate platform, which is some of these AI issues that are coming down the pike.
Great, thanks, Hill. And before I dive into that, I've got some breaking news related to our first segment, which is that the fired Democratic commissioners have indeed sued President Trump. So we will see how that litigation will play out. There's a very good chance that it will percolate up to the Supreme Court, who may take another look at their 90-year-old precedent in this area. So what I want to talk about now is AI. Let's go to our next slide, and I'm going to do this on kind of a whirlwind basis because there's a whole lot to talk about. So let's go one more slide there. When Hill and I go to conferences that are kind of geared around antitrust practitioners, I'd say the last 4 years or so, a huge percentage of the content is about AI, and the enforcers in particular are very active in stating their views and their concerns with AI. And it can be, summed up in these quotes. It's, sort of fundamentally the idea that we may end up in a world where AI is fixing prices. And it could be that different algorithms are talking to each other and learning to collude with each other. It may be that a single algorithm is learning to set cartel-like prices for all of its users. And I think actually the kind of the dream case that a lot of enforcers are looking for, and it's probably still a few years off, but that dream case is probably where you don't even have humans really directly involved in anything, and it's just two different algorithms talking to each other and at least allegedly fixing prices. So I think one day we will see that case being filed. For now, what we are seeing is lots of statements of enforcement intentions. We're seeing some litigation, which I will talk about in a little bit. We're also seeing the enforcers, particularly the antitrust division, leaning in on litigation by filing statements of interest. They just filed one in a healthcare case involving an algorithm yesterday. And so this is one area where we are seeing a lot of activity from the enforcers. So let's go to the next slide. I want to just flag for you all some of the major ways in which AI and algorithms can be cause for concern in the competition sphere. And we could probably talk for hours and hours on this slide. Obviously, I'm going to do this in just a couple minutes, but let me just sort of flag for you what the issues are. So the first one we have here is standard setting. You could also just describe that really in this context as the development of safety standards. And that's because AI is developing so fast, so exponentially, that it raises a lot of different concerns. Some of them being about, AI being deployed in a way that is, there's unlawful bias. Other things are much more scary, frankly. There's existential threats to humanity, Skynet type, activation. And the main way that you control for this is that the leading developers of AI could talk to each other about developing safety standards that are essentially, okay, if we see that our AI is exhibiting these types of qualities, these potential threats, we are going to develop standards or have an agreement with each other that we're going to put on the brakes. We're going to stop development or pause development until we get our arms around that. But that is a sort of a traditional area of antitrust concern. That is arguably simply a per se illegal and potential criminal offense if you are talking with your competitor about restricting your output. So that's one way in which antitrust has a view and a say, arguably, with respect to AI and algorithms. Another one has to do with labor markets. There's the recently announced Joint Labor Task Force at the FTC has concerns about gig work and algorithms being used to determine, what pay is going to be there and how that could be, adverse to the gig workers. Another concern there is that there's such a limited pool of highly qualified engineers to do the AI development work that there could be agreements among the companies that are employing those folks that are anti-competitive, and that's a real concern. That there's already been some prior history in that space, but that's given how few people are really competent to do this development work and the fierce competition for those employees. That's a very big concern. The third issue on this slide here is the idea of killer acquisitions, where you have incumbent firms acquiring, up and coming firms, innovation targets, solely just to ward off future competition. So that's an area where antitrust may have something to say. Another one that's somewhat related is that you could have the dominant AI firms looking to entrench their dominant positions, monopoly positions, by restricting, critical inputs. And those are things like, cloud computing services. But the last issue, and where I'm very briefly going to dive a little bit deeper, has to do with algorithmic price fixing. And that's the idea of using common pricing algorithms, which you see in quite a few different markets, with either the goal or the net effect of charging higher prices than would be used if that algorithm was not deployed. And so let's go to our next slide here. One more, and I just want to talk about some of the industries where we're seeing algorithmic price fixing being deployed and where we've already seen litigation. One of these is with respect to multifamily housing. There's litigation against RealPage, which is a software provider, Yardi, which is the software provider. And these litigations, they are multi-district litigations filed by plaintiffs in a class action context. And with respect to RealPage, there's also a case that was filed by the DOJ Antitrust Division. All of those are pending at the moment, and I'll get to a slide that talks about the different results there. But multifamily housing is one place where we've seen very active uptake of pricing algorithms being used by multifamily lessors. Let's go to our next slide. Another context, which is fairly similar, has to do with casino hotels. And a software company there that provides revenue management software. There were two different sets of cases, one involving Las Vegas Strip hotels, another involving casino hotels in Atlantic City that challenged the use of pricing algorithms in those environments. Let's go to our next slide. Another place where we see pricing algorithms in use is in the healthcare industry. And there's a company that was formerly known as Multiplan that has rebranded to the name Claritev that has developed pricing revenue management software that is used with respect to out-of-network reimbursements for healthcare services. There's ongoing litigation there. So let me jump to the next slide, which talks about kind of the results of these cases. And to be honest, we have not had great consistency in the results of these cases. We've had in the RealPage case.
Can I jump in, Mike, just to stop you for a second? If
Yep.
anyone has had trouble with the polling, go ahead and send us an email in the chat, and that will confirm that you were on here, and we'll work it out later. But go ahead, Mike.
Sure. So just some takeaways on where this litigation stands. I think we've had very mixed results. In the RealPage case, the MDL court denied the motion to dismiss, but declined to apply a per se standard because he determined that it was not a straightforward price fixing conspiracy and that this was kind of a novel way of doing business. So arguably, this was kind of half a loaf for the plaintiffs. They did not get per se treatment that really streamlines the case for them, but the case was allowed to proceed to discovery. In the Yardy cases, there was a different result and this was a much more recent result on the motion to dismiss, in that the judge determined that at least on the pleadings, he found that the allegations were of a per se conspiracy. So that case has now moved on to discovery with, at least for the time being, a per se analysis being applied. In the casino hotel cases, we had a very opposite result. We had the result being that the motions to dismiss were granted and with prejudice, and those cases are up on appeal. And that really had to do in large part with the extent to which confidential information was being shared through the algorithm and used as a pricing input for the various casino hotels. And then lastly, in the Multiplan MDL that I referenced, there is a motion to dismiss that is currently still being briefed. The government actually just filed a statement of interest yesterday supporting the plaintiffs in that case, and we're expecting a result fairly soon. So let me, given that we've got 3 minutes left, let me just jump right away to some of the takeaways that we've learned from this litigation as we think about AI issues. And let me just say, next slide, please. Let me just say that none of these sort of best practices and considerations for you are talismanic. But I think if you think about all of these things and perhaps apply many of them, they can help substantially mitigate your risk as you contemplate engaging with a pricing algorithm in some way. One of the key things to do is to avoid communicating with your competitors regarding the use of AI. So this would include things like, discussions at trade associations that are commonly, the focus of antitrust allegations. Don't talk to your competitors about what they are doing with respect to the use of AI. Another thing you can do is have your engineers, and if you need to, retain a third-party engineer to assess what the AI system you are contemplating using is actually doing. understand what the rules are, understand what the goals are as they are written into the code, and understand how that might present some degree of antitrust risk for you. Another thing you can do is don't just sign on to an AI system, set it and forget it, and then just walk away. This is something that regulators emphasize all the time. You can't just let an AI system run on autopilot and check in with it every couple years. It has to be something that you are actively monitoring. Regulators will tell you this over and over. And, again, I mentioned that the dream case for a regulator is an algorithm that is self-improving, talking to another algorithm that is self-improving, and all of a sudden you've got two AI that are colluding with each other. And if all it was needed was some humans to step in and keep that from happening. So it's another way that you can help protect yourself. One other thing you can do is you can ask whether your competitors are using an AI system, just so that you understand the degree of market penetration, and then you can understand the risk level as to whether or not you have other companies in your industry doing the same thing. But what you should not do is ask for details about the specific ways in which your competitor may be using the system. One other thing you can do is that you can try and place controls around the information that is shared with any AI you are using. If you can, make sure that any confidential information that you are sharing with that AI is firewalled off from any use with your competitors, and that you are not receiving any information from your competitors through the AI system. And then the very last thing that we've seen some clients do quite successfully is they have just developed their own proprietary AI tools. So there's no issue of using information that is obtained from competitors in the AI system. So that is a incredibly quick whirlwind. We're out of time. I don't know, Hill, if you've seen any questions that we can address pop up in the chat.
One question, and thanks for folks for telling us if you had any trouble with the polls. If you did not have any trouble with the polls, that's great. You don't need to send us a chat. We'll fix all this on the back end. Thank you very much. One question, I'll go ahead and answer it, is given that the Trump executive orders have said that they're going to do things like sanction law firms for taking positions in cases that are unreasonable, do we think that we're going to find people, law firms, being pulling their punches at all if they are defending mergers that the antitrust agencies have said are unreasonable? They're filing a lawsuit against your merger. I don't think so. I guess I'm hoping more than thinking, but I'm hoping and thinking that the Antitrust Division, the FTC, are not going to take positions that defending your merger gets your law firm in trouble. I'm also very certain that that would create enough of a explosion that there would be a unified law firm front in fighting back in the courts against that. So I don't see it happening, and I do think that we would all basically get together and fight, because that's our. But representing mergers and getting that done is bread and butter. But the Trump administration has said that they want to dial down the rhetoric against mergers that the Biden administration antitrust enforcers had. So I don't see that being a major source of fight. Then again, I have not been perfect in predicting a lot of things that the Trump administration has done. So I guess we will see. Thanks very much, Mike. Thanks very much to everybody who joined. And with that, I think we can end. We're going to save the chat. And please contact Mike or me if you have any other questions. Thanks, guys.